Namaskar friends, welcome back to Corporate and Securities Law Compass. Today we are discussing one of the most important and practical provisions under the Companies Act 2013, Section 5, Officer who is in default. This provision is extremely important because whenever a company violates any provision of the Companies Act, the next question always becomes, who will be held responsible? Will the company alone be punished? Or will directors and officers also face penalties? Section 5 answers this very important question. Let us understand the provision in complete practical detail. Under corporate law, a company is an artificial legal person. A company acts through human beings. Therefore, whenever a company commits a default, the law identifies specific individuals responsible for that non-compliance. These responsible individuals are called officers who are in default. Section 5 defines who can be treated as an officer who is in default for the purpose of liability, punishment, penalty, prosecution, and regulatory action under the Companies Act 2013. Now, let us understand the legal meaning carefully. An officer who is in default means any officer of the company who is responsible for compliance and who knowingly permits, authorizes, participates in, or fails to prevent the default. This provision becomes extremely important during MCA investigations, ROC actions, adjudication proceedings, prosecution, penalty orders, SFIO investigations, and regulatory non-compliance matters. Now let us understand who are specifically covered under Section 5. The first category includes whole-time directors. Suppose a company fails to file annual financial statements within prescribed timelines. The whole-time director responsible for management may become officer in default. The second category includes Key Managerial Personnel. This includes Managing Director, Chief Executive Officer, Company Secretary, Chief Financial Officer, Manager. If any compliance failure occurs due to negligence or inaction, these officers may become personally liable. Now let us understand an important practical example. Suppose a company fails to conduct annual general meeting within statutory timelines. The ROC may impose penalties not only on the company but also on managing director, company secretary, responsible directors because they are treated as officers in default. Now another important category under Section 5, any person under whose instructions the board of directors is accustomed to act may also become liable. This is very important in practical corporate governance. Sometimes promoters control company decisions without holding official designation. If such persons influence management decisions leading to default, they may also face liability serious. However, professional advisors acting in professional capacity are excluded. For example, advocates, chartered accountants, company secretaries in practice, legal consultants giving professional advice alone will not automatically make them officers in default. Now let us discuss another important provision. Where there is no specific KMP, the law shifts responsibility to directors specified by the board. The board may authorize specific directors responsible for compliance matters. If no such authorization exists, then all directors may become liable. This is extremely important for small and private companies. Suppose a private company has no company secretary and no managing director. If the company fails to maintain statutory registers, then all directors may potentially become officers in default. Now let us understand the role of company secretary under Section 5A. Company secretary plays a critical role in ensuring board compliance, filing compliance, secretarial standards, maintenance of records, regulatory disclosures. If non-compliance occurs in areas under the company secretary's supervision, then liability may arise. This is why compliance monitoring is one of the most important functions of a company's secretary. Now let us understand another practical example. Suppose a company accepts deposits illegally in violation of sections 73 to 76. In such case, company, managing director, CFO, company secretary, and responsible directors may all become liable as officers in default. This shows that liability under Companies Act is not restricted only to the company. Personal liability can also arise. Now let us understand why Section 5 is extremely important from governance perspective. The objective is to ensure accountability in corporate management. Without personal liability, directors and officers may ignore compliance obligations. Therefore, Section 5 creates responsibility and discipline within corporate administration. Now let us discuss an important practical issue. Can independent directors automatically become officers in default? The answer is not always. Independent directors are generally liable only if they had knowledge of the default, consented to the default, connived in the default, or failed to act diligently. This protection is extremely important for independent governance. Now let us discuss another important example. Suppose financial statements contain false disclosures. The CFO may become liable because financial reporting falls under his functional responsibility. Similarly, if secretarial filings are not completed, the company secretary may face consequences. Functional responsibility plays a major role under Section 5. Now let us understand another legal aspect. Section 5 operates together with various penal provisions across the Companies Act. Whenever any section states, every officer in default shall be punishable, the meaning of officer in default must be understood from Section 5. Therefore, this section becomes the foundation provision for corporate liability. Now let us discuss a boardroom situation. Suppose the board delegates compliance responsibility to one director through a board resolution. That director may become primarily responsible for defaults in assigned areas. This is why proper delegation and documentation are extremely important. Board processes and minutes play major evidentiary role during investigations. Now let us understand the importance for startups and private companies. Many founders assume only the company will face penalties. That is incorrect. Directors, founders, KMPs, and compliance officers may also face monetary penalties, prosecution, disqualification consequences, and reputational damage. Therefore, compliance culture is extremely important from the beginning. Now let us understand another important concept. Mens rea or knowledge may become relevant in certain cases. If an officer knowingly authorizes a violation, liability becomes stronger. For example, deliberately falsifying financial records, knowingly hiding related party transactions, intentionally avoiding statutory filings can create serious personal exposure. Now let us discuss the role of board oversight. The board of directors must establish internal compliance systems, reporting mechanisms, legal monitoring processes, and periodic compliance reviews. Failure in compliance governance can increase exposure under Section 5. Now let us quickly revise the key practical points. Section 5 identifies individuals responsible for company defaults. Liability may extend to directors, KMPs, compliance officers, promoters controlling management, and persons responsible for compliance functions. Independent directors receive limited protection unless involvement or negligence is established. Professional advisors acting purely in advisory capacity are generally excluded. The provision promotes accountability, transparency, and corporate discipline. Now let us conclude. Section 5 of the Companies Act 2013 is one of the most important provisions relating to corporate liability and accountability. Whenever a company violates the law, regulators always identify who was responsible, who controlled compliance, and who failed to act. That identification happens through Section 5 for directors, company secretaries, CFOs, compliance officers, founders, and corporate professionals. Understanding this provision is absolutely essential. Because under corporate law, non-compliance may create not only company liability but also personal liability. Thank you for watching Corporate and Securities Law Compass. If you found this explanation useful, then like, share, and subscribe for more practical discussions on Companies Act 2013, SEBI regulations, corporate governance, board processes, secretarial practice, compliance management, corporate litigation, and securities law updates. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.